Welcome back. It's Philip Bickle at Legal Tyranny on July 1st, 2021. And this is another filing in my huge case over here in Hawaii. I should say cases because the way that they handled all this, they didn't combine the infractions and the criminal side, the no driver's license, no insurance, like they should have. There's actually a statute for that. So, as you see up here, this is infraction, traffic infraction, 3rd District traffic infraction. 2016 is when it went down, and yes, it's 2021, and I'm still dealing with the traffic case. Am I nuts? No, this is all in principle. I got nothing else to do. I can't work. I've been injured for over 20 years. So, you guys can come along on this description of essentially what was primarily just a statute of limitations issue raised here. At the time that I filed this, I was pretty burned out. So I believe I had already filed the criminal one, and there were a lot more details in that. I could have included substantially more in this one, but again, I was just burned out. I get arthritic symptoms with my hands. I can only, do so much typing. And really, if you have a good issue and others are a little, sketchy, you could do yourself a service by focusing on that one issue and maybe make that the primary and only thing that you raise in an appeal. But if you have several good issues, like I did in my criminal appeal, and let's see the cases, or the case there at the trial level, if they're good, just bring up all the points. But don't bring up something that's kind of wishy-washy. You're wasting your time. You're wasting their time. If you aggravate them, they may be more inclined to rule against you. They're human. They're not supposed to be. They're supposed to be completely unbiased, but we all know better. Okay, so this is the opening brief and a certificate of service. It's 19 pages. The table of contents is structured the same as in the criminal appeal. All the same sections. The argument goes into way more detail for the statute of limitations. It was one of the few things that I was going to raise for the infraction side. I had a couple others, but I just didn't have the time, and again, time and exhaustion. So I decided to focus on this one thing, and rather than kind of hit it, it wasn't entirely superficial. I hit the things I needed to hit in the criminal side appeal. This one will have statutory code cited within the actual brief so that you'll get to see what it says, and you'll see, like, I know what I'm doing. I've studied their code. They had no excuse for just dragging things out and attempting to charge me way after the statute of limitations. Okay, so structure's the same. Our points and authorities are not going to be the same. Again, everything is heavily truncated here. We lopped out several cases because they didn't have anything to do with this particular point. So, let's see, the statutes also will be different, the ones that are cited here. And the at least one of the issues raised with the amendments is new. Okay, so got our statement of facts. Let me see how far in we are. Not very far, so let's go ahead and get started. Statement of the facts. Now, for those of you that have already listened to this, you might want to just pause this and skim over it, because many of the things I point out here are going to be the same as in the criminal side, because they all stem from the same incident. However, there might be a couple of new things here. I'm not going to find that difference right now. I'm too tired. I'm on 5 hours of sleep, but I wanted to get this out for you all to be able to think about. So you can possibly come across a couple new things. I think the way I did this might be new. But otherwise, if you want to listen, go ahead and listen. I'll read it again. On November 11, 2016, Officer Clarence Davies III conducted a seizure of Philip Bickle, defendant appellant, and his automobile over an alleged traffic violation. On November 17, 2016, Officer Clarence Davies III filed citations 3DTC-16 blah 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 and 3DTI-16 blah blah blah. Criminal infraction at the courthouse in Hilo, Hawaii, alleging violations of Hawaii Revised Statutes, Chapter 249, 286, and 431. An unknown court clerk took these citations and treated them as if they were filed by a prosecuting officer who is authorized to initiate prosecutions on behalf of the people of the state of Hawaii by the filing of a verified charging complaint with the clerk. Court cases were created under the same numbers as the citations, so to be clear, there were 2 cases created for multiple alleged offenses from the same episode. They should have made 2 separate cases. There's a statute, it might be like 714 something, I think. I'll probably have it listed in here later. But it indicates they're required to combine these things. So any of you that wind up with stacked charges or a bunch of things charged, if they try to set them for separate cases or hearings, demand that they combine them. Unless you have that extra time and want to take advantage of having extra hearings. I did that. I took complete advantage of that, and they know it. I learned from my, where I left things out or mistakes. So when I had those extra hearings, I just drilled them on additional things. But if you don't have the time to be screwing around, get them to combine them because 1, it's efficient. 2, there's probably code that says they have to. And again, the whole principle is let's be efficient. So let's see, paragraph 4. The initial answer by myself to the notice of infraction pointed out the fact that Officer Davies, who filed the notice of infraction, made a warrantless seizure and arrest of myself and my property for alleged non-criminal violations, something expressly forbidden in the Hawaii Revised Statutes, HRS 803-5. And I also have a huge argument with citations in this particular filing. Maybe I'll throw that one of these up later. I'd like to get all these up. I just want to get it up. I mean, I put the time into this, and people can learn from it. Okay, Judge Henry Nakamoto reviewed this answer and did not initiate any probable cause hearing to determine if the warrantless seizure and arrest were lawful. There was no proof provided by the prosecution that this action was lawful. On December 29, 2016, judgment was entered for the state on all counts. See the record on appeal. I filed a timely request for a trial de novo. I think I may have done a better job citing for every single fact here, like every point, in fact. Yeah, it looks like I did. You want to make sure you do that, guys. Always have your citations, because that's what they're going to rely on to say, okay, yes, he did file it in timely response. And if you can, give them the, page number, line numbers where appropriate. Just make it easy on them. It's professional, and they'll appreciate that. Okay, even if they're corrupt. Trial de novo was scheduled for March 30th, 2017. On March 14th, 2017, I filed a motion and memorandum to suppress evidence on the basis of Officer Davies conducting an unlawful warrantless seizure and arrest. On March 24, 2017, the state prosecutor filed memorandum in opposition to my motion. I filed a motion to recuse Judge Udovik on grounds of bias and prejudice on March 28, 2017. On March 30th, 2017, a hearing was held on a motion to recuse and a motion to suppress evidence. The motion to recuse was denied by Judge Udovik. He reviewed his own motion to recuse. He had no business doing that. He should have passed that up to the whoever their head judge is for the court, because they don't list them online or anywhere else. I don't even know how they select them. Some sort of seniority. They have these per diem judges, which is what Udovik was. They come in. They have a schedule, I guess, maybe a month out, but they're the ones that tear through these traffic cases and pull in money for the judge's retirement account and the private corporation known as the District Court of Hilo. If you look, that's another quick aside for you guys. Any of you interested in going deeper, if you jot down Dunn and Bradstreet, D-U-N-N and Bradstreet. That's one word, Bradstreet. That's a corporation that has a listing of big and small businesses. Back before they adjusted their website, they actually had courts, all the courts in California, courts in other states. Probably, I guarantee the courts over here, all of them are listed. They all have tax identification numbers. So they're basically pulling in profits for who knows who. I mean, maybe the judges or other bar members have these things set up. The police offices, they even had a U.S. Navy filing showing its presence in Great Britain. I mean, it's just nuts. Like, if you look at the fight, you want to get to the heart of a lot of things, follow the money. Always follow the money. But if you look at that, the Dun and Bradstreet, you'll be shocked if you could still get that info. Just put in the name of the court. If it's like Superior Court of California, just plug that in and do a search on that, and you'll see them popping up. Okay, on topic. Sorry, I'm sleep deprived. All right, State Witness Officer Davies III testified and was cross-examined. Arguments were made by State and myself. Judge Udovik denied the motion to suppress. Judge Udovik granted my request to make an interlocutory appeal on the denial of the motion to suppress. And from what I remember studying, you have an actual right to appeal a ruling on a motion to suppress if it's against you before trial. So you're allowed to get that settled before. And again, it's an interlocutory appeal, because in this case, I was dealing with at this point, let's see, I was dealing with the fact that I hadn't even been charged. So they're required to do that. I mean, it's just such a blatant, outrageous violation of any concept of being fair that, this stuff should be national news. I don't need my face out there. If I wanted my face out there, believe me, I'd put it up on YouTube and let the internet do the rest. But that's not my thing. I'm just interested in trying to get this corruption reined in. I mean, we've got a very, very bad path ahead of us right now. So this interlocutory appeal, this thing should have been granted. The Intermediate Court of Appeals is now dealing with these exact issues in a appeal made after the trial, which is your typical appeal. When people talk about appeals, usually that's what they're talking about. There's been some sort of judgment entered. These interlocutory appeals are special. Google it and learn about them. there's something you absolutely want to know about, because if you plan on raising statutory issues, then you're going to want to be able to know when you should appeal something if they violated some sort of substantive right in the whole process of whatever it is you're dealing with, whatever the proceedings are, family court, whatever. These things will apply. So, also, they may have separate rules to some degree for the circuit courts and district courts on when these things can be filed. So you just have to immerse yourself a little bit in the code and familiarize yourself with that. Okay, I filed a notice of appeal regarding the motion to suppress ruling on May 2nd, 2017. On February 1st, 2018, the Intermediate Court of Appeals dismissed my interlocutory appeal on alleged grounds of no jurisdiction. Again, right there they were saying that I made an appeal before a judgment was entered, and they just flat out either didn't read what I wrote, or they read it, they knew I was right, and they were trying to avoid dealing with me and hoped, that I would just give up or whatever. Things would be dealt with outside of their court without them having to address this issue. And in fact, if and when they make a ruling, I wouldn't doubt for a second if they avoid the failure of them to bring charges, and they'll try to find something else to dismiss it on, or reverse it on if they're going to reverse it. Okay, we're going to cut this in half right here. If you found this useful and informative, please hit the thumbs up. And if you're not subscribed, please subscribe. And please help by manually sending links to my channel or to videos that specifically would get the interest of other people that might be interested in certain topics. So let's try to help out other people that maybe don't have the time or the capacity to comprehend what they should be doing research-wise to kind of home in on issues that they could raise in cases that they have at court. So until next time.